David Grusch, a particularly prominent UFO whistleblower who arguably sparked it all with congressional hearings and, mainstream TV interviews, has just had his lawsuit that he filed against the Loudoun County office dismissed from court, which could be pretty huge for a multitude of things, including what whistleblowers do moving forward and how safe their secret information actually is. So, let me give you a bit of a rundown about what happened, because there's a lot of context to this which provides a bit of an understanding as to why the lawsuit was submitted in the first place and what's led to the dismissal of this lawsuit, full stop. So, back in 2023, in July, David Grusch, who is a retired US Air Force officer and former intelligence official, gained public attention when he testified before Congress alleging that the US government had secretly been involved in quote-unquote crash retrieval and reverse engineering programs related to UAPs. Now, Grusch also claimed to have had knowledge of non-human spacecraft and deceased pilots based on information from credible sources within the intelligence and military communities. And his testimony sparked a significant public and media interest, but also drew scrutiny and skepticism, particularly regarding his credibility. Now, that's obviously where we're going to be diving into, because it was that led to some things to happen and then also led to the subsequent lawsuit. Now, following his congressional testimony on August 9th of 2023, The Intercept, through journalist Ken Klippenstein, published an article revealing details about Grusch's mental health history. The article cited police incident reports obtained by the Virginia Freedom of Information Act, FOIA, requested from the Loudoun County Sheriff's Office. These reports detailed two incidents, one in 2014 and another in 2018, where Grusch was involved in situations related to his struggles with post-traumatic stress disorder, depression, and alcohol use. The 2018 incident involved Grusch's wife reporting him for being intoxicated and suicidal, leading to his involuntary detention for psychiatric evaluation under the emergency custody order and a temporary detention order. Now, the article noted that despite these incidents, Grusch retained his security clearance, which raised questions about the government's handling of his case compared to other employees. Now, Grusch and his supporters, including investigative journalist Ross Coulthart and former CIA officer Tracy Walder, alleged that the release of these records was part of a deliberate smear campaign by elements within the intelligence community and Department of Defense to discredit him after his whistleblower testimony. And they argued that the records, which included sensitive medical information, were improperly released and violated the Virginia privacy laws. And this led to Grusch actually filing a $2.5 million lawsuit against the Loudoun County Sheriff Mike Chapman and an unidentified Sheriff's Office employee on July 16th of 2024 in Loudoun Circuit Court. That was the reason for the lawsuit. That was the amount of the lawsuit, and that's why it first went through. So just for a little bit of context for everyone, because then we're all on the same page and you understand what's going on. Now, the reasons for filing the lawsuit. Obviously, there was the alleged violation of the Virginia privacy laws. There was the claim of intentional harm and smear campaign. There was personal and professional harm, so basically defamation. Discovery of a strategic goal. Broader implications for whistleblower protection. Now, these were the kind of the guises as to why this lawsuit was initially submitted. Because, basically, the lawsuit was framed as a defense of whistleblower rights and privacy protection for veterans, and Grusch and his supporters argued that using his mental health history to discredit him set a dangerous precedent for other whistleblowers, particularly those with PTSD and similar conditions, and the case raised questions about the balance between government transparency under FOIA and protection of sensitive personal information, particularly those in the public eye, like David Grusch really was back in 2023 and 2024, and arguably still now. Not as much for sure, but, he was back then. Now, ultimately, the lawsuit was completely dismissed, and we know this because it has been made public information. So David Grusch's $2.3 million lawsuit against Loudoun County Sheriff Michael Chapman, a member of his staff, that has been permanently dismissed. Grusch filed the suit after Sheriff released the two journalists Ken Klippenstein a police incident report containing details of an episode that led to Grusch's involuntary commitment to a mental health facility. Grusch's name was redacted on the report, but Grusch was identifiable based on other information within the document. Yesterday, the court heard Sheriff Chapman's demurrer, which argued that Grusch's remaining claims for the gross and willful negligence fail to, as a matter of law, even assuming of the facts that alleged by Grusch in the complaint were true. The judge has now held that the release of the redacted incident report was authorized under Virginia's FOIA law, and that the sheriff showed some level of care in the release because any showing of care defeats gross negligence, and willful negligence requires conscious disregard. Grusch's 2 remaining claims were dismissed. As Grusch's complaint was dismissed with the prejudice, it cannot be refiled. And then this was the order. This matter having come to the court on the amended demurrer filed by the defendants, Sheriff Michael Chapman and Mary Ellen Clark, and upon consideration of the demurrer, the opposition of plaintiff defendants' reply and oral argument, it is hereby ordered that the demurrer be and the same hereby is sustained without leave amend, and it is further ordered that the plaintiff's complaint and this case be and hereby are dismissed with prejudice. Now, you're probably wondering why it got dismissed, because obviously that doesn't state why it got dismissed. It just says, well, it kind of does, but, not in a lot of depth. So the lawsuit was dismissed with prejudice by the US judge on August 7th, meaning that Grusch cannot refile the same claims. While the exact reasoning for the dismissal was not detailed in available sources, several factors likely contributed to the court's decision. So this, of course, isn't the exact reasons, I must, stress for the sake of the video, but we can get an understanding. So the first one was legal grounds for the FOI compliance. So according to the judge, the Loudoun County Sheriff's Office maintained that it acted lawfully in responding to Klippenstein's FOIA request. There was a weakness in the complaint. So some legal observers on platforms like Reddit noted that the complaint was poorly constructed and unlikely to survive the motion to dismiss. There was qualified immunity, so the Sheriff's Office and Sheriff Chapman likely invoked qualified immunity, a legal doctrine that protects public officials from lawsuits when acting in their official capacity. There was a lack of evidence or improper motive, so while Grusch alleged that a smear campaign orchestrated by federal agencies, the lawsuit may not have provided concrete evidence linking the Sheriff's Office to such a conspiracy. There is the procedural or jurisdictional issues, so the dismissal could also stem from a procedural flaw, such as filing for the wrong court, so for example a federal versus state court, or failing to meet statutory requirements for a civil suit against a government entity, which of course the police department would be. And public interest and FOIA policy. So courts often balance privacy rights with the public interest in government transparency. The Sheriff's Office argued that the records were part of a routine FOIA response, and the court may have prioritized the public's rights to access law enforcement records over Grusch's privacy claims. So that's where we stand with that. Now, what happens moving forwards? This could potentially be, and this is what's being touted across the internet, as a potential blow to the whistleblower community, because people will be wondering, well, if people can just so easily access my medical records and, just submit an FOIA request to the police department and the courts won't protect me, then I don't necessarily want that private information out for the public scrutiny. So it might deter a lot of whistleblowers, which, people are now saying is the idea of the smear campaign, I have to put it in quotations now, because it's a messy one, isn't it? This is just government through and through, and this is one of those ones. But what do you think? Should the dismissal have stood, or do you think that it was wrong? Let me know what you guys think down in the comments below. Way down there, jump to the hell out of the like button and subscribe, and until next time, I'll speak to you later. Peace.